We have a common interest in justice here on this channel, and that's one of the reasons why we talk so much about court cases, because courts are really the venue where the practice of justice really happens, where it's done in a real practical sense. There's an old saying that if there's no remedy, there's no right. No right without a remedy, and that's getting at this sense of the importance of the role of the courts, because if you have a right, it doesn't do you any good if you don't have some mechanism to be able to enforce it. And so because of that, it's a really particular injustice when somebody is barred from being able to seek relief from the courts. So this is an important topic that I wanted to talk about. And we're going to do something a little bit different here, which is look back on a historical case, probably the most significant civil rights case that you have never heard of. This is going to take place during approximately the end of the Western expansion period in the United States. So we're talking about within a couple of years of Custer's last stand, Sitting Bull's escape to Canada, Chief Joseph's flight to the Canadian border. The encroachment has kind of reached the tipping point now to where there's no more frontier, and the solution of how to live together between the European settlers and the American Indian tribes is coming to a head. And this has taken place in a really unique legal context, as well as a historical context that you probably have some familiarity with. So I have with me today my favorite podcaster. He's the creator of the History on Fire podcast, which you can find on Spotify or anywhere that you get podcast subscriptions. He also has a YouTube channel for History on Fire. I have been following his content for many years. I also subscribe to his Patreon, which you should do as well. And he has covered a lot of these topics dealing with the Native American conflicts in the West. Many wonderful episodes about Crazy Horse, about Sitting Bull, about all kinds of other parts of this era in American history. So I encourage you to go check all of that out if you haven't already. I've raved about it before, so hopefully you may have already have some familiarity with it. But because of this, I'm so extremely pleased to have with me today Professor Daniele Bolelli is here to share with you the story of the Ponca Indian tribe and leading up to the Standing Bear petition for a writ of habeas corpus in the U.S. District Court.
Thank you so much for having me and for the very sweet, kind words. So let's go play. Let's look at this story. Clearly, you are the legal expert. I'm going to be providing more the historical background and the lead up, the more general context to the story. The general context is a weird one because, as you mentioned, this time period is primarily known for the wars and the conflict and the military conflicts between the Cheyenne and the United States, the Lakota and the United States, the Nez Perce and the United States, even if you move a little southwest, the Apache in the United States. Mm-hmm. That's not what's going on here at all. The tribes we are looking at right now, primarily the Ponca, but also the Omaha, since they were a related tribe. They used to be part of the same tribe, and then they split. But even calling them two tribes is a big word, because many of people usually have brothers or sisters within each other tribes. They are so closely related. But these two tribes had a history that, from a military standpoint, would look unremarkable, because these guys stayed at peace with the United States from pretty much the early contacts down to forever afterwards. We have, an early mention by Lewis and Clark running into them during the Lewis and Clark expedition and commenting about how friendly they were. Just talking a little bit, I guess, about their lifestyle. They discuss how they would primarily rely on farming corn. They had these sedentary villages along the main rivers throughout the Great Plains, and then they would go on an annual buffalo hunt during the summer. Fairly mellow lifestyle, no conflict with the US. We don't really hear of anything from them other than signing treaties on a fairly regular basis with the United States And the treaties all follow the same pattern, which is the Ponca/Omaha giving up land, agreeing to give up land to the United States in exchange for a promise that they will, whatever they get to keep, it's theirs forever, and they will be taken care of, and there will be supplies. This is a choice that many tribes have to make at this point, because many tribes see the writing on the wall, see what's happening, see the conquest is about to happen, whether they like it or not. So many of them figure, let's take the best deal we can, get to keep at least some of our lifestyle, and come through the other end of this process of conquest in the least painful way possible. Ponca and Omaha do exactly that. I should mention, by the way, that they lived in the area of what's modern-day Nebraska/Iowa/southeastern portion of South Dakota, right around that area. So the problem, of course, is that their case is the textbook case for, even if you decided to be friendly to the United States, usually things didn't work out either. Because, you can see the choices of tribes that take a more militant stance and criticize it as, well, maybe if they weren't so aggressive, they would have gotten a better deal. Not really, because you see the tribes that decide to fight get most of their land taken. The tribes that decide to be friendly get most of their land taken. So it doesn't really seem to make a difference, even though at least in words it sounds like it would. That just simply not what's happening in reality. So one of the things that happened is that by the second half of the 1870s, the government decided to push the Ponca out of their chosen land where they had lived for generations and send them to Oklahoma. Oklahoma was becoming, and had been actually for a good chunk of the 1800s, a dumping ground for native tribes whose lands the government wanted. They would dispossess them of the land, send them to Oklahoma. And, I want to be nice to the folks living in Oklahoma, but it seems from the way they describe it that the government attitude was, nobody else wants to live in Oklahoma anyway. Just send them all there where no one else wants to go, and we'll take land that we actually care about. Now, the Ponca, as you may imagine, are like, hey, come on, we gave up so much already. We are just asking, we're not bothering anybody. We're just asking to continue our life in these little plots of land that we have left. Can we just do that? And the short answer is no, you can't. You got to go. And I mean, if you really don't like it, sure, then you can come back. So in 1877, some of the leaders of the tribe take an exploratory trip down south. They reach Oklahoma. And, the climate was so different, the resources weren't pretty scarce. So they see many of the tribes that have been settled there in more recent years. They see them struggling dramatically. So they're like, well, no, we don't want to come here. The government agent that had been in charge of selling them on this plan is really upset. So doesn't provide for any money for their return trip. The leaders, however, despite no money, no food, they managed to make it back home, bringing the news. This is a terrible idea. We really shouldn't do it. Now, here is where a more general point that applies to these guys, but also applies to so much of the policy toward native peoples during this time, which is an unfortunate point that needs to be made, is that the whole process of the way reservations were run was corruption is the name of the game, essentially. There was a term that critics of this system used. They refer to it as the Indian ring. And what they are talking about is a whole group of people, from politicians, government agents, bankers, land speculators, everybody, both in public sector and private sector, who was going to find ways to benefit by taking resources that were supposed to go to the tribes and instead pocketing them for themselves. And I'll give an example so we know what we're talking about. Every tribe was assigned an agent to run the reservation. The prevailing idea was like, you guys are too stupid to handle money or to handle your own affairs. We need some government employee to do it for you. Now, of course, this person was in more cases than not, found very creative ways to make sure that money that was supposed to go from Washington to the tribes would end up in their pockets. They would, maybe in accounting, they would say, oh, I bought 100 cows for them, but then they would buy the cheapest, sickest cows they could find at below market price and pocket the difference. Or they would flat out lie. They would say they spent money to build the schools, to do this, to do that stuff they've never done, and they just pocketed the money. When the tribes complained, the government agents would blame Washington. When in turn Washington asked, hey, why are these tribes complaining? The government agents say, these guys are crazy. It's a pain to deal with them. Just, I'm showing you, I can show you how I've spent all the money. You see, I've done everything by the book. So in these branches of the government blaming each other, natives got screwed over. And, politicians got kickback to turn the other way. Bankers, merchants, land speculator, everybody got a deal. And at the price of the conditions that the tribes would have to deal with. So that's the context behind the whole thing.
So it might be helpful too to at this point talk a little bit about the legal context that really allowed that situation to flourish, this massive corruption on just a scale that is a little bit hard to contemplate today. There's a series of cases that took place in the early 19th century that began to define the relationship between the United States, the state governments, and American Indian tribes. And so these cases, the very first one was called Johnson versus McNaughton, and it concerned a land dispute over what was at the time Cherokee land. And so what had happened is a Cherokee member had sold some of his land to a white person. There had subsequently been additional transfers and basically transfers like on behalf of the Indian man as well. And so that created a dispute over the title, who actually has good title to this property, because more than one person is claiming it. So this was a quiet title action to basically establish, okay, given these different conveyances, who's the true and rightful owner under the law. And so in that case, the U.S. Supreme Court took a look at the situation and basically held that American Indians don't have the right to sell their own property. And the reason why is because this was quite literally and explicitly grounded in the law of conquest. This notion that because European people on ships had sailed by and seen the shore, from a distance and laid claim to it for their sovereign, that essentially gave them the title of the conqueror to pretty much everything that they saw. And then, of course, they argued amongst themselves about, well, I saw this coast, you saw that coast, and we don't exactly even know how the continent is configured at this point. So nations are disputing with each other about who owns it. So where does that leave the tribal people, the indigenous people who are already there? Well, they have what the court refers to as aboriginal title. So because they're there and they're not at war, they're going to continue to have the right to live in their normal and accustomed places, but their title is inferior to the claims of the U.S. government as the conqueror. So the U.S. is concerned about things like, well, what if one of these tribes were to sell off their property to a foreigner, somebody maybe who has interests contrary to the United States? The United States is not a particularly large country, geographically speaking, when this is taking place in the early part of the 19th century. So that could theoretically pose a fairly big national security type of risk. So at the same time, there has been a long tradition among the European nations, as well as the young American nation, of engaging with American Indian tribes like their foreign nations through the treaty process, through diplomatic procedures where we enter into agreements about kind of how we're going to live together, but you run your sphere, we run our sphere, and we will just get along as mutually independent sovereigns. So in these early cases, what happens is that sovereignty is kind of defined down into a position of dependence to the United States. They're characterized specifically as dependent, domestic dependent nations in one of these cases. And so essentially what that's doing is the court is saying, we're going to treat you and recognize you as a separate independent entity, a category. So you are not like all of the other European settlers in the United States. You're not a citizen. You're not entitled to the same kinds of rights and privileges as U.S. citizens would be. But at the same time, because you're within the territorial limits of the United States, we're not going to treat you as fully independent either. We're going to make you be subservient to us as the conqueror. And so for that reason, the relationship between the United States and Indian tribes is typically, and from very early on, the very earliest cases, it's conceived as analogous to a guardian's responsibility to a ward, that obviously extremely, racist in these types of assumptions. But the Indians are these inferior people. They don't have the enlightenment of Christendom. So in our benevolence, we need to look out for their best interests. Kind of like you're saying, they're too stupid to deal with their own affairs is a lot of the underlying assumption here. And it's important to realize when we're talking about justice as a project and an undertaking, that is literally written in the law. And so a little bit of a disturbing background there. So because the Indians are not in a position to be able to manage their own affairs, and they're subservient to the U.S., they have to ask for permission to develop their property, to live where they're going to live, and so forth. This creates a situation where when the U.S. government owes the American Indian tribes something, such as through these treaty obligations that they undertook to pay certain amounts. And this, I want to point out, this is largely because in displacing Native American tribes from their homelands, you're alienating them from their traditional means of subsistence, especially when we're talking about the Plains tribes, which includes the Ponca and Omaha, the Lakota, the Cheyenne, a number of these other tribes. These are heavily dependent on the buffalo hunt, the buffalo movement. So you need pretty large amounts of land to be able to sustain that ecology for that lifestyle. So when you start moving tribes to smaller and smaller parcels of land, expecting that they will just adapt and become farmers, that's not necessarily going to be a thing that you can just snap your fingers and it's going to happen overnight. There needs to be a transition to sort of develop that. Some tribes are going to resist that change in their lifestyle anyway. That's not what they're obligated to do under the treaties. But at the same time, it's just not practically realistic anymore to be able to subsist on the buffalo hunt. So because of this, the United States undertook that there are certain amounts that we're going to basically pay the Indian tribes through these treaties. And that's essentially what they're meant to do, is to make up for this loss of the subsistence livelihood. And so because these obligations from the U.S. government, they have to be managed for the benefit of the American Indians. So the federal government gets to manage its own obligations under the treaties. And it does this by creating this system, this bureaucracy to handle these payments and to account for them, to manage them for the tribes, to buy things that the tribes need. The tribes certainly could not be expected to, decide for themselves what sort of buildings they needed or something like that. It would all have to be run through somebody who can trace their authority back to the United States government. So this is the context that is just like, it's the fox and the hen house scenario. When you have somebody who maybe isn't all of that, doesn't have all that much integrity when it comes to that responsibility of the guardian to act in the best interest of your ward, it's just a very easy situation for them to be able to self-benefit. And so an important part of the reason why that is as well is because at this point in time, the American Indians don't have a mechanism to go to court to force the United States to live up to its treaty obligations or to complain, you promised this, but it's not being carried out. We need some type of redress. That traces back to the second of the Marshall Trilogy cases, the Cherokee Nation versus Georgia, in which the U.S. Supreme Court looked at a set of laws that the state of Georgia had passed that purported to essentially end the Cherokee reservation. It was going to take the land, allot it out, it had all of these rules for what you could and couldn't do on the reservation. And this was pretty clearly and pretty self-evidently, it was contrary to the treaty and, not at all consistent with the federal government's approach. So not really any question that there was a wrong here in terms of, Georgia, you don't have authority, you don't have jurisdiction over this property. You don't get to negotiate treaties with Germany. Why do you think you would be able to engage like that with the American Indian tribes? So Cherokee Nation sued the state of Georgia, and they sought the original jurisdiction of the U.S. Supreme Court for lawsuits, controversies between a foreign nation and a state. So it presented squarely to the U.S. Supreme Court the question of, are these American Indian tribes really on the same footing that we would give to a foreign nation in terms of their independence or not? And the Supreme Court in that case held that they're not. Basically, not our problem. Yeah, we can go through in detail all the ways that these laws are problematic, but this sounds like really more of a political type of problem than something that the courts should be engaged in solving for our purposes, because you have this domestic dependent nation status. You're subject to the plenary power of Congress. Congress essentially gets to do whatever they want with you, and that makes you different from somebody like Germany or somebody like France, who then would have the right to come to court and ask for recourse over these types of violations. So the last mechanism that was available for potentially for an American Indian to seek recourse against the United States for these types of violations is the U.S. Court of Claims, which was created in 1855. So like all governments, the U.S. government has sovereign immunity. They can't be sued unless they give you permission to sue you. Incidentally, this is one of the few rights of a sovereign that courts have recognized American Indian tribes have as well. So this 1855 statute basically waived the United States' sovereign immunity for purposes of claims that you could bring against them. But the problem is this statute specifically excluded American Indians from its coverage. So what we have then at this situation, at this time in history where these events are unfolding, we have the inability to seek direct recourse against the United States for any type of wrongdoing by the United States in this relationship. We have the relationship defined in these very dependent terms where you as the conquered person are subject to the authority of the United States as if they were your guardian. So you must have permission from them to act, seek, their leave to basically assert your rights in any kind of meaningful way. And they are then also responsible for administering these day-to-day necessities that you are depending on for your livelihood in a context that is just kind of custom made for the possibility of this type of corruption that unsurprisingly emerged from it.
Yeah, there are a couple of things that I think are worth emphasizing in what you brilliantly brought up and outlined, the development of this relationship of like a guardian or acting as sort of trustee and all these weird roles that are... The thing that's funny about it is that the theory, no matter how paternalistic or even downright racist we can see it being today, it would be bad. But at least if you actually stick to it, there would be something. The problem is that it doesn't work like that. So, for example, we see cases when, like you mentioned, for example, buffalo hunting tribes. You look at people like the Ponca and the Omaha. Did they buffalo hunt? Yes, but it wasn't even a primary. These guys did farm for most of their subsistence. They did the very things that the government was telling them. You need to learn to do these things in order to be considered civilized. They did all that. And the idea was like, yeah, but we still want your land. So you still need to go. It's like, no, wait, we are actually successful at farming and doing the very things you're asking us to do on our land right here. We are starting schools. We are creating churches. We're doing everything you ask us. And it's like, yeah, but the land is a little too good for you. Let's send you to a new land where farming is terrible and you don't know what you're doing and you'll probably starve, but so there's this kind of thing where it's like part of the problem is that the lack of consistency in like the theory, regardless of whether the theory is just or not, doesn't really follow through with practice.
Yeah, it's a situation where historically it's hard not to look back on this and see the sabotage built into some of the decisions. Like if you look at what the policy is at the time and the type of lifestyle you're trying to promote, we have tribes that are basically doing exactly what you would want them to do. And so what is our solution? It's to undermine their ability to do that. And that really underscores the hypocrisy that has emerged from this legal context where we're going to characterize this as a guardian ward scenario when it's beneficial, but when it's not, we're going to just go ahead and disregard it. We love to talk about American Indians having this dependence on the government, but the government having responsibilities towards the people that they're administering. This is not so much a popular thing to be raising and thinking about. And that's really kind of the stain from my perspective that arose in this era and is still structurally built into the law today, that Congress has this plenary power over Indian affairs. This is, I don't want to be too dramatic, but in many ways probably the closest thing to a tyrannical, despotic type of system that we've really had in this country. Especially at this time frame where, again, American Indians they're not citizens, they're not afforded the right of citizens, and even if they did have rights, they have no recourse to the court to be able to enforce them in any meaningful way. So legally, the posture here is one of essentially desperation. There is no clear avenue available in spite of injustices that even at the time, people are aware of these things, raising concerns about this type of thing. But, just not a situation where the courts are going to be willing to throw open the door then and, offer justice for these wrongs that everyone can see are being perpetrated.
Yeah, even, we'll get back to the Ponca in a second, but like even in what you brought up regarding the Cherokees, which is the Marshall Trilogy in the 1830s was sort of the foundation of laws that then affect Native Americans in this country. Even in the cases that work the best for the tribes, when they do score a victory in the highest court of the land, in the Supreme Court, it still doesn't work out because at least in one of those cases, when they get what they want, the state of Georgia completely ignores the Supreme Court ruling. So what you should have is the same thing that happened, for example, in the 1950s with civil rights legislation that was approved by the Supreme Court. Some states didn't want to go along with it, and so you had the federal government applying pressure to force the states to go along.
Mm-hmm.
In this case, Andrew Jackson was president, and he sat to do it like, I could not care less. I'm not starting a civil war with Georgia over what? Over Native American rights? Give me a break. So sure, you can put the law on paper somewhere, but I'm not going to do anything about it. And so you have the cases of some tribes where they do win in the highest court in the land, and it still doesn't mean for it. Like, it's a win on paper only because in practice it gets to be ignored. And so you're
literally, this paper says you have rights. Now, good luck trying to do anything about it.
Yeah. And we see this thing over and over with this idea of the relationship, the guardianship relationship. Like people who have seen, for example, the movie Killers of the Flower Moon, you see that exactly how that relationship works out in the darkest possible terms when the people who are supposed to be helping the tribe on the quote unquote helping you become civilized are the ones who are taking advantage of the tribe for their own benefit.
And it's really not hard to imagine, too, how with no oversight in this type of situation, the potential power that you can accumulate as that guardian, that's going to be enormously tempting. I mean, you can look at in the European context, like in regency situations, for example, if you have a succession issue and you have a minor heir, the palace intrigue that will emerge over the ability to care for that heir and maintain that heir. We're seeing some of that story if you're watching the Shogun series on FX Hulu right now, which I am, and I love, by the way. A lot of those types of influences are going to be present in this type of relationship. If you can control a powerful resource, that resource might as well be yours. So if you have the authority to decide what happens with Indian country belongs to you for all practical purposes.
Yeah, it wasn't exactly because there was no oversight. They didn't even bother hide the corruption all that much. I mean, I remember researching and running into documents where they found the real accounting that some agent would take for the reservation. And they would list out bribes to politicians, like openly, like, oh, and I had to set this aside to pay off this judge to make sure they look the other way. And things where you're like, okay, it's pretty clear how the system works. Like, it's not a failure of the system. It's pretty much designed to be corrupt. It's not like corruption is not a bug, it's a feature kind of thing.
Yeah.
And we definitely see it happening here in the Ponca case when the Bureau of Indian Affairs, despite the fact that they told the leaders, if you don't like it, you got to stay where you want. Then they say, oh, you don't like it? Well, that's too bad. You're still going to Oklahoma. They send the army to forcibly remove them. The army then destroy everything they left behind, the homes, schools, churches, you name it, trying to make sure that they have nothing to go back to, just in case. And now you have what, for all intents and purposes, become a death march, since between poor supplies, lack of proper nutrition to go along the trip, and once they get there in the first few months, different climate, people start dying like flies. We see Standing Bear was the leader of the Ponca tribe. You see his daughter dying, his son dying, his sister dying. And this is not even an unusual thing. It's like a bunch of people in the tribes are having family members dying left and right. The straw that breaks the camel back for Standing Bear is when his own son dying is asking him, bring me back to be buried among our people, back to in our homeland. And so he feels like if we stay here, we're gonna die. There's nothing we can do. He does have, in one desperate shot, he does manage to arrange through the Bureau of Indian Affairs a meeting with President Hayes. So again, this is like it looks like a big win, right? It's like you get to meet the president and voice your grievances. And Hayes pretty much pats them on the back, goes like, just make the best of it. I'm sure you're gonna make it work some point down the road. And basically just don't bother me, I don't want to hear about it. And so this is the make the best of it is told to guys who are seeing all their family members starving to death and dying left and right. It's not exactly the great help that, I mean, even for somebody like Standing Bear who believed in the relationship with the government, believed in what he had been told about, we can work with the United States, he realized he's being betrayed plainly and clearly. So he organizes an escape of just a few people. Like, we're talking about little over a couple of dozen people who escape from the reservation in Oklahoma to try to make it back to their homeland. This escape is very different to something that will happen just a couple of years later when another tribe, the Northern Cheyenne, after being defeated in war, will be sent to Oklahoma, will run into the same terrible conditions. And when they escape in a much more militant way. They will get into lots of fights with the army. It will be a big military event. the Poncas do nothing like it. You know, the only interaction they have with settlers is settlers sometimes they see them go by starving and desperate, and settlers feel bad and feed them, kind of thing. There's a lieutenant with the army, John Burke, who would later describe what the Poncas had done and their migration north, saying that they went about it molesting nobody and subsisting upon charity. Not a shot was fired at anyone, not so much as a dog was stolen. So this is again the Poncas fit to a T this idea that they are never resisting, they are never fighting, they are going about it in the friendliest ways possible, even when their own family members are dying all around them. By the time they get up north, their presence is noticed. The army comes in to capture them and arrest them. Specifically, the officer in charge is General Crook, who was one of the most famous officers involved in the wars against Native American tribes during this period. He had fought against the Apache, the Nez the Lakota and Cheyenne, you name it. But despite the fact that he was primarily a military guy in charge of war, he had demonstrated, relatively speaking at least, a much higher degree of sympathy than many other officers. So he's actually feeling bad about this. He's feeling like, I don't want to know, like I know what I'm sending them back to if I send them to Oklahoma, but you know, what else can I do? At this juncture, the daughter of Standing Bear's brother was a leader in the Omaha tribe, pressure her father to go speak with Crook, trying to do something about it, trying to help out, essentially appeal to him for help. And Crook goes to visit a journalist named Thomas Henry Tibbles, who worked for the Omaha Daily Herald. He had been a supporter of John Brown, had served during the Civil War. Crook felt like if anybody could be sympathetic to the Poncas, this guy could fit the bill. And so he essentially asked to help out, which was a big request because clearly siding with a tribe that's trying to gain back land in an area that has all been given away to local settlers is not necessarily the most popular stance one could take. Could be a risk to his career, never mind his life. So, and Crook is saying, look, I get it. I know I'm asking you a lot. I'm going to help any way I can. You know, if it was up to me, if me resigning from my job, if I believed that by resigning from my job, I could prevent this from happening, I would do it. But the reality is that they're going to send another officer who's going to take them to Oklahoma and the same thing will happen. So can we create a campaign? Can we create enough of a hoopla around the story where maybe he is essentially dumping the hot potato in Tibble's hand, saying, help me figure out what we can do about it.
Yeah,
and
he's trying to shift it to the court of public opinion a bit, and I think trying to solve the situation through political pressure is really his goal. That if you can get enough people in the press, then this is the classic set of incentives that we have for Washington. If you're worried that you're not going to get reelected, then you'll go along with whatever the pressure is of that campaign. So that's really kind of the approach that he's seeking them to take, because of course he doesn't have the ability to get out of his own chain of command and not obey this order. He's subject to this order, and you know he'll be court-martialed if he doesn't follow it. But he clearly sees it as a great injustice. Crook he had a very, like you mentioned, I was fascinated to learn about his history with the Indian campaigns, because of course he was such a big figure. I think it was part of his army that, you know, was in the area, the vicinity of Custer's last stand when that happened. He's been involved in a lot of these conflicts, and yet despite that, he had enormous respect for the American Indians and the American Indian tribes. Crook himself was he's a very humble, unassuming kind of guy. He was notorious for not wanting, didn't wear his uniform if he didn't have to. He would just be out in civilian clothes, and he rode a mule, which is some of the greatest pictures. If you look up pictures of Crook, you'll often see him, seated on a kind of short little mule. So this is not a guy who has these big vanities about, what it means to be a white Christian, settler at this time, a big general. He's not puffed up with self-importance at all. And I personally think that's probably a big part of the reason why he was able to appreciate the American Indians and their culture on that just kind of practical level. I think in many ways they kind of did live a similar lifestyle. Obviously, he's a general and things are different, but he's a mobile person, kind of living a little bit more of a harsh kind of life than you might expect in a settled kind of community. So
absolutely, and the thing that's interesting about him is that he even brings up a point saying, we have a little weapon, not much of a weapon, but we have something we can do, because the orders I received were for me to arrest them. They did not explicitly say that I was to return them to Oklahoma, even though everybody knows that that was the meaning of the order. So until they realize that I haven't sent them back, and then they yell at me saying, hey, send them to Oklahoma, officially I don't have orders to do so. So I'm just going to detain them, get something done before Washington realizes what's happening. And that's when Tibbles goes lawyer shopping, try to find somebody, which again, it's a big ask in itself, because he has to find somebody who's going to be willing to work pro bono on a case for native rights. Again, not the easiest thing possible, but he does find a couple of really good lawyers who agree to give it a shot. So
he does.
Where it gets interesting here in the legal case.
So he finds a pair of lawyers, John Webster and Andrew Poppleton are their names. They're both very well established lawyers in the community. They're very well regarded. And they also, importantly, were very interested in the 14th Amendment, which at this time, remember, is still pretty new. The 14th Amendment was passed by Congress in 1866. It was ratified in 1868. So, a little bit, slightly more than a decade before this time period that we're ending up in court here. And so obviously with the 14th Amendment, there was a lot of debate and public discussion about civil rights generally and what this was going to mean to really kind of make real this commitment that our founding fathers had articulated and envisioned, that all men are going to be created equal. Everybody is equally subject to the law and has the same rights as everybody else. Of course, from today's standpoint, that doesn't seem all of that remarkable. But for that time period, this was pretty revolutionary. And the idea that the states could be held accountable for that was particularly novel. Prior to this, the Bill of Rights was largely understood to only apply to the federal government. It didn't create any obligations on the parts of the states. And so, okay, the federal government can't take away your right to speak, take away your right to practice religion, can't quarter troops in your house or things like that. But there was no specific guarantee that the states could not do that as well. So that's one of the things that the 14th Amendment accomplished. But at the same time, this didn't resolve the question of the status of American Indians. The 14th Amendment itself, if you read the text, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. You read that language plain, it sure sounds like that should apply to American Indians who are born here and who are clearly under this Marshall Trilogy subject to the jurisdiction of the United States, of the federal government. But no, it was generally understood that did not apply to American Indians. American Indians remained not citizens and continued to remain not citizens until 1924, when Congress specifically passed the Indian Citizenship Act. This is largely in recognition of voluntary service of a number of Native American service members during World War I. So this is a context where, again, we're developing these ideas of equality and really starting to put some meat on the bone of what that means in real life. But there's this inconsistency then with the treatment of Native Americans. They still remain kind of this exception. And so there's still a lot of questions and debate about is that right? Is that appropriate? So these particular lawyers having that interest turned out to be a great choice. They were interested in this case. They were willing to take that on and to go ahead and fight that battle. And so what they did is, on behalf of Standing Bear and 7 of the adult men who had fled the Oklahoma reservation with him, he filed for a petition for a writ of habeas corpus. Now, habeas corpus, it's one of the oldest legal remedies that exists in the common law. It's dates back to 12th century England under Henry II. Basically, first gave the people the right. And it's, from my perspective, I'm a criminal defense lawyer, so bear that in mind. It's one of the most important protections that we have against tyranny, because if you don't have a way to hold the sovereign to account for depriving you of your liberty, for throwing you in prison, maybe taking your life, taking your property, that type of thing, then you don't actually have any rights. You just live under a despotic system. So it's really critical in a rule of law based society, like I think we want our democracy to be, that you have these mechanisms available to be able to hold the sovereign to its own standard. So the writ of habeas corpus was one of these first original bulwarks against tyranny, and that's what they invoked. And this petition basically alleged that because the Poncas were being held without authority of law, that General Crook basically, there was no legal justification for the order compelling him to arrest them. And so because of that, the petition requested that they be released. The case was presented to Judge Elmer Dundee of the...
Sorry, I should bring up a thing that I think is hilarious in this case, that Crook, the guy who is actively going out of his way to try to help the Ponca, in this case, he's the defendant. Like, he looks like he's the bad guy in this story, because they are like, you are depriving them of their liberty. And so it's funny because nobody's aware that actually Crook's sympathy, until he gets on the stand, are on the Ponca side, because he's looking like he's representing the government, but that's not where his sympathy lie at all.
Yeah, it's a great strategic movement from a general, right? To kind of realize, when is it good for me to lose? Exactly. Maybe back away. That way I don't necessarily have to fight this battle that I don't really want to fight. So he's the one who is got the order. He's the one who conducts the arrest. He is the defendant in the case, and the writ would compel him to release them, which is really what he wants to happen anyway. But because he has the obligation to follow the orders of his chain of command and, probably not question them too vigorously, and certainly not publicly, he needs to go through the motions of presenting the defense. So procedurally, this case, it happens pretty quickly. During this period, the Poncas, they are being detained in a military prison in this area. And so they had been removed from the Omaha reservation, where when they had finally arrived back from Oklahoma, they went to their old friends, the Omaha, who hadn't yet, had their own issues with removal and so forth. And the Omaha welcomed them in, said, yes, here we have this extra land that we're not using. You're welcome to use it and farm it. And that's essentially what they were engaged in doing. They were beginning to plant their crop for the following fall. This is all happening in like the March of 1879 timeframe. So it happens very quickly. The judge, Elmer Dundee, he initially does issue the writ. And this is like what we would call today kind of the ex parte process, where you go to the judge with an emergency, something, a petition is for a writ of habeas corpus, in this situation is considered an emergency type of process. So you can go to the judge and get some temporary relief until there's an opportunity to have a full hearing on it. And then basically the judge decides whether to make it permanent or not. So if you're familiar with like a restraining order type of process, very similar to something like that. So Judge Dundee does initially issue the writ. There's kind of a funny story about the timing of how this happens, because as you mentioned, Crook had this narrow little window between his orders don't explicitly say that he has to send the Poncas back to Oklahoma, but we know those orders are going to arrive any day when the government realizes the Poncas are not going anywhere yet. So there's all of this concern to get this done as quickly as possible before those orders arrive. And it's troubling because Judge Dundee is off on a hunt and nobody knows where he is. So there's this process of trying to hunt him down, finally finding him late in the afternoon and getting him to sign this writ before any orders arrive from Washington. So a little bit of serendipity there with the timing that set the stage for what was to come with this case. So he issues the preliminary writ, and Crook is required to answer it, which he does. And his argument is essentially, this is the order that I have. That's my lawful authority. I was commanded to do it by, my chief commanding officer, President of the United States, through his representatives. And I don't really have any ability to do anything else but enforce it. So that's why I did what I did. So it comes to a hearing, and the hearing addresses some specific points that the petition had raised that were necessary under the circumstances, I think, to make this legally and probably, I'm sure, also politically palatable. The way that the petition was framed was to allege that Standing Bear and his compatriots, they had expatriated from the Ponca tribe. They had left the tribe, severed their relationship. They are no longer Poncas. They had sought to come back into the area of their origin so that they could essentially live like white men. They wanted to adopt the white man's ways. They wanted to maintain themselves through their own labor, and put away, their tribal type of way of doing things. And because of that, the petition argued this is really necessary to try to get them out from under that congressional plenary power authority that we have, where, Congress is a despot. If they say you need to go to Oklahoma, then you need to go to Oklahoma, and they don't have to have a rhyme or reason to it. And if you don't like it, you don't have any recourse to do otherwise. So to get them out of that type of setting, they had to pitch it. At least this is my read on the case, as these are not actually Ponca Indians. So rest assured, court, you're not making any, overwhelming type of decision that could potentially affect all of the people down there on the reservation in Oklahoma right now. We're just talking about these ones that are no longer tribal members. So they allege that because of that, they had the right to leave the Oklahoma reservation and to basically, live as white people would live, right? This is putting the 14th Amendment to the test. So they go to a hearing, and much of this hearing is focused on these details of whether they have or have not expatriated from the tribe. The government is trying to bring up things like, you still, you Standing Bear are still kind of a leader to these other men. You're still like a chief in your relationship with these other men that have come with you. You did still continue to accept benefits from the U.S. government as a tribal member because, for example, they had traveled back from Oklahoma in a wagon that they had received from the proceeds of the original treaty. So really trying to pitch it as, this is a farce. You haven't really left the tribe. Standing Bear himself gets an opportunity to testify. He's called as a witness, but Judge Dundee does something quite extraordinary in this case with respect to Standing Bear, because normally only people who are practicing barred members of the court, of the bar, get to address the court and say what they think, say what the judge should do, what their pitch is ultimately for the court's ruling. When you're just a witness, you're there in the box, you're there to answer the questions that are asked of you. You're not allowed to speak contemporaneously off the cuff and just say whatever you want to say. But Judge Dundee, I think, thought it was important that Standing Bear have the opportunity to be able to speak for himself in this courtroom. And so he, kind of like General Crook, found a little loophole that he was able to exploit to make that happen, which is that the rule to address the court, to be requiring you to be a member of the bar, that applies in open court. So he closed the court. He formally concluded the court proceedings, but nothing really changed. Everybody's still sitting there. And so it was really just a kind of formal decision that was made. And that enabled Standing Bear to be able to present his position to the court. So I'm going to briefly read the description of his speech that Thomas Henry Tibbles wrote. It's in his book, Buckskin and Blanket Days, if you can see that. It's a fun read. I recommend it. He's a very interesting character in his own right. But so describing this particular incident, he says, Standing Bear rose. Half facing the audience, he stretched his right hand out before him, holding it still so long that the audience grew tense. At last, looking up at the judge, he spoke quietly. That hand is not the color of yours, but if I pierce it, I shall feel pain. If you pierce your hand, you also feel pain. The blood that will flow from mine will be of the same color as yours. I am a man. The same God made us both. Half facing the audience again, he let his gaze drift far out through a window. His tone grew tense. I seem to stand on the bank of a river. My wife and little girl are beside me. In front of the river is wide and impassable, and behind are perpendicular cliffs. No man of my race ever stood there before. There is no tradition to guide me. Remember, American Indians have never been allowed into a United States court before. This is a really revolutionary place where he finds himself. Then he described how a flood began to rise around them and how, looking despairingly at the great cliffs, he saw a steep, stony way leading upward. Grasping his child's hand while his wife followed, he led the way up the sharp rocks while the waters still rose behind them. Finally, he saw a rift in the rocks and felt the prairie breeze strike his cheek. I turned to my wife and child with a shout that we are saved. We will return to the swift running water that pours down between the green islands. There are the graves of my fathers. There again we will pitch our teepee and build our fires. But a man bars the passage. He is 1,000 times more powerful than I. Behind him I see soldiers as numerous as the leaves of the trees. They will obey that man's orders. I too must obey his orders. If he says that I cannot pass, I cannot. The long struggle will have been in vain. My wife and child and I must return and sink beneath the flood. We are weak and faint and sick. I cannot fight. He paused with a bowed head. Then, gazing up into Judge Dundee's face with an indescribable look of pathos and suffering, he said in a low, intense tone, "You are that man." So this was quite a moment, as I'm sure you can probably imagine, given the detail that Henry Tibbles took down and wanted to convey to the rest of the world to see. This had a big effect on the courtroom, described as, people crying in the audience, people very deeply affected by this speech.
Including the judge himself and Crook, which is like, that's quite a speech.
That is exactly what you want out of your closing argument. If you pull that off every time, you're gold.
All teary-eyed, and my question has always been on this, and of course there's no answer. I was always wondering if this was 100% Standing Bear, or if he got a little bit of a quick tutoring in Shakespeare, The Merchants of Venice, because of course the speech, at the beginning of the speech at least, is very reminiscent of that. The whole the hand, if I pierce mine, it's
Mhm.
almost not word by word, but getting pretty close. So I was like, oh, that's interesting. It was, but in any case, we'll never know. What we do know is that the speech was powerful and it had the intended effect in terms of the emotional impact of it all.
Well, part of the reason why we know it had such a big emotional impact is because when Judge Dundy then decided the case in early May of 1879, he told us. He told us specifically how much it affected him. But again, it's one of these contexts where there's a lot of bitter delivered with the sweet in this
Oh, yeah.
opinion. A lot of stuff that is now again embedded in the law that we continue to apply today, that maybe we might wish is not altogether there. So he does talk about his sympathy, but that's largely because he characterizes the Poncas as a few remnants of a once numerous and powerful, but now weak, insignificant, unlettered, and generally despised race. He contrasts this with General Crook, who he describes as the representative of one of the most powerful, most enlightened, and most Christianized nations of modern times. So this is pretty much one of the best articulations of that paternalistic mindset that you described. That you might be able to hope to find in a official source like this. Very clear that from the power standpoint, he sees the government and Crook as holding all the cards. So one possible way to look at this decision is a little bit of taking the sting out of what is to come. Like I said, I'm a criminal defense attorney. Courts have been known to compliment me on the quality of my argument shortly before they rule against me on every single thing that I say. It's kind of a courtesy, to just let counsel, you did a good job. It's really not your fault, but this just isn't going to work for a lot of reasons. So I'd like to think that perhaps that was a little bit of the motivation that Judge Dundy had when he's describing the parties in these types of ways.
I think it's likely because if he's taking no matter how small it looks to us, because the decision is a win in a very small way, considering that Standing Bear and his friends have to give up being tribal members. They no longer have a whole... So there's, it is a win, but it's not like a dramatic revolutionary win. But considering how much of... I'm looking for, I guess the word I'm looking for is kind of like there's this sense that he's still an upset. He's still a big, like nobody thought that could happen. So the judge knows that he's taking a stance that's not a popular one. And so he's probably, as you say, try to take the sting out of it by in a way laying the guilt trip on anybody who may have a different opinion, going like, come on. You are the highly civilized, very Christian, smart, brilliant people. Why don't you take pity of this poor wretch down here? I think he's smart about it. Like he's doing, maybe he believes that stuff. That's also possible that there's maybe a 50-50. But also I think he may be playing it by arguing, we say all these things, how civilized and good we are. How about we live up to it for a change? How about if we do say that these guys are poor and inferior, why don't we treat them with the kindness that the civilized one is supposed to have toward the uncivilized one?
And not just the kindness, but give them the equality of the law, the access to the courts that we have already guaranteed to everybody else under the 14th Amendment. Here's the crux of this conflict that we still have. We didn't resolve it. We fought an entire civil war over these ideas of how humans should relate to each other on a platform of equality. But when it comes to the American Indians, we're still not providing them with that same type of equality. So, spoiler alert, obviously, Judge Dundy, he does grant the writ. He essentially finds that, yes, the detention was without legal authority, and therefore the writ has to be issued. Standing Bear and his friends, they need to be released from prison. There's a few holdings that he had to make to get to that point. And this is where, again, when you look at the Indian law cases, you just there's a lot of stuff in it that is going to have downstream effects that maybe aren't necessarily considered at the time that they're made. And so with Judge Dundee, he's very careful with his ruling in some respects, but he's also it goes a little bit beyond what's necessary to really decide the issues in others. And I, again, think part of this is probably with the need to make it somewhat, at least politically palatable. So the first holding that he made was, on the one hand, it sounds like the least controversial one, but on the other one, it really was the revolutionary holding, because it is what kicked open the courthouse door for American Indian claimants. He held Standing Bear is a human being. Human beings are who are entitled to seek a writ of habeas corpus. The state had tried to argue, the government had tried to argue that this is a right that's reserved to citizens. And the court just basically rejected that argument, looked at the statutory language, said that it applies to any person who is in custody or unlawfully restrained. So all we have to decide, Standing Bear is a human being. Really sad that has to be a revolutionary legal principle, but it was, and that is really the big win that they got in the case. The second holding, that is one of the maybe a little bit more troubling ones. Maybe it could be viewed as a positive as well, because it's putting Indians on a similar footing with pretty much everybody else. Is it recognized the right of expatriation, the right to sever your association with a tribe and decide you're not going to be part of that tribe anymore. This is something that citizens have enjoyed under the First Amendment. You have a right of association. What goes along with that is the right of dissociation. You have the right to not maintain relationships that you don't want to. And so to recognize that the Poncas are just like everybody else, even if they're, not really in possession of all of the same rights as citizens are. Nevertheless, this is a basic natural human right that they share. Now, of course, it's troubling because to the extent that holding is really necessary to support the decision is not really clear. And Judge Dundee doesn't necessarily make it very clear either. He does include some language in his opinion that suggests, in his view, unless Congress is relying on the war power or the executive is relying on the war power, there may not be any legal authority to order American Indians to go anywhere in particular or to stay confined on a reservation. The treaties don't say that. So what then would be the basis for the executive to make that decision? The legal argument would be, well, it's Congress's plenary power. Congress can, order American Indians to do whatever they want whenever they want to do that. So it's this tightrope that he walks where he seems to basically be trying to set it up so that it's a win either way. That in his opinion, you, U.S. Army, you don't have the right to be moving any Indian people places they don't want to go, whether they are tribal members or not. But just in case that doesn't work, maybe at a higher court or maybe for political purposes, we'll just go ahead and find that, yes, they have the right to not be tribal members anymore and that they had, in fact, severed their tribal relations. So as someone who deals in the appellate world, I'm kind of used to seeing judges frame their decisions in ways to protect them, to preserve them against the review of a higher court, and little but even ifs that often get built into the decision. And this seems to me to potentially be something like that. The last bit of the holding is the one that is kind of the letdown. That's it. Because it has to do with the claim of legal authority to be able to detain the Poncas. So General Crook had relied on his order that had come down from Washington. Judge Dundee looked at the situation this way. He saw that under the law, as Congress had provided for it to be, you are not allowed to be present on the Omaha reservation if you are not an Omaha tribal member. The exception to that is only if you got the permission of the Indian agent who, may or may not, depending on whether it's in his interest for you to be there or not, could grant it or deny it pretty much at his whim. So because of that, this law did technically make it illegal for Standing Bear and the other Poncas to be on the Omaha reservation. They didn't have the permission of the Indian agent. But the statute required that if they were going to be removed from the reservation, that they would have to be delivered up to the civil authorities in the nearest jurisdiction for due process of law. And that obviously hadn't happened in this case. They had simply been imprisoned, and the prospect was that they were going to be shipped back to Oklahoma. So there was no legal process really contemplated for them at all. So he basically said, this is certainly a power that Congress has granted, the ability to remove intruders on the reservation. But if they have that authority, it has to be exercised in the manner that Congress has provided for. And Congress has only said, this is how you exercise it. You take them to court, basically. So because they didn't exercise it in the manner that the statute contemplated, it was illegal, contrary to the law. Therefore, the writ had to issue, and Standing Bear and his compatriots had to be released. So it's a good result. But it's one that rested a little bit on a technicality and not so much on the sort of broader principles of equality and justice and fairness and so forth that we might hope a court could rely on when they're addressing a wrong.
Yeah, that's what's crazy, that, you have the military authority in charge agree that this is an injustice. You have, of course, the Ponca, the Omaha, a bunch of settlers agree that this is an injustice. The judge agrees that this is an injustice, but the only way to get around it is that by barely squeeze through on a technicality.
Mm-hmm.
It's like, wait, what? I thought we all, that part is disturbing.
Yeah.
And also some of the legacies too are disturbing of it, because one of the things that happened shortly thereafter is that Standing Bear's brother named Big Snake was still in Oklahoma, doesn't want to be in Oklahoma anymore, realizes that there are options, want to leave. He's also upset for other issues as well, because at this time his son, like many of the kids of the tribes, as well as many other tribes, were forcibly removed from their parents and sent to boarding schools.
Mm-hmm.
Not only they are sent, like, you don't get to have a choice where your kids stay with you or they are relocated to a boarding school, but also you don't even get to see them in summer, because they would usually rent them out as servants to local families. So, they come in, take your kids, and good, you'll see them in 6, 7, 8, 10 years, something like that.
Mm-hmm.
Talk about a violation of basic human rights, right? So Big Snake is not in a good mood. He has plenty of reasons to be upset. He wants to leave Oklahoma. And that's when he gets into a clash with the reservation agent there. Reservation agent doesn't want to let him go once Big Snake arrested. He resists and they shoot him dead, which is something that happened quite a lot at this time. Like, the number of American Indian leaders who are, quote unquote, resisting arrest and end up getting shot in the process is pretty high during this period of time.
Yeah.
So it's another one of those, if this is the great shining feel-good story in terms of the native experience with the law at this time, it takes, you really need to want to see the glass as half full to be able to see it as a feel-good story, because there's plenty about it that's still terrible.
Yeah, and it was a great decision for Standing Bear, but ultimately it didn't have a lot of benefit for anybody outside of this particular dispute. sort of characteristic of the U.S. federal law system. The district court, he's not a precedential judge. His decision isn't binding on any other judge in the country. It doesn't establish rights for any other claimant. For that to happen, it would have to go up to a court of appeal, a reviewing court, and they would have to basically make a decision about it. And then that decision ends up being precedential. It applies to everybody. There were some procedural maneuverings with this case. Basically, the appeal was initiated by the state, but they kind of messed some stuff up and it was getting complicated. And ultimately, they just decided to drop it. Of course, you never really know why the state decides to drop a case. They don't have to say, they don't have to give an explanation for it. But it certainly doesn't seem that hard to believe that they were concerned about the possibility of a decision against them on appeal that would then, in fact, be precedential. And part of the big concern, too, might be because Judge Dundee had opened these doors in terms of talking about the rights of people, not just tribal members versus non-tribal members. If people have the right to be free from unlawful restraint, then that would seem to undercut the ability to confine American Indians on these reservations that we've ordered them to. So strategically, you can kind of see why that might have been a good call for them to make, to not risk that type of decision coming down.
And I guess that's where, I mean, maybe with the terrain, maybe we'll cover it on a different day, but like, it's interesting when you look at, like I mentioned one example, the boarding school. So you essentially not have a right as an American Indian to raise your own kids. Kids will be taken away from you, whether you like it or not. But again, when you look down the list, there were other things that maybe worth looking at sometime, like the fact that there was, despite the whole idea of the Bill of Rights, freedom of religion, all the religions are equally protected, the practice of native religions had no protection whatsoever, and a whole bunch of their ceremonies would remain outlawed until the 1970s, when Congress will pass a piece of legislation saying, oh, yeah, that the freedom of religion business, we also meant it for Native Americans, because up until that point had not been true. So it's really, when you look at it, is like some of the most basic things that we all take for granted, things like freedom of religion, you get to have choices, so now you raise your kids, all of that stuff just did not apply to the tribes, did not apply to the tribes before they were citizens, and in some cases did not apply to the tribes even after they became citizens. So it's, yeah, when you look at like obvious cases of legal injustice, it's like you can blindly throw a dart anywhere, and when it comes to the Native American experience, you pretty much hit it every time.
Well, and I think you've hit on something that's so important, which is really why would we still be talking about this case today? Why does this even matter? This case from 150 years ago. I've described it as probably one of the most important civil rights cases that you've never heard of, because it had, from a conceptual standpoint, it was a massive shift, but the actual practical effect of it, it's really quite limited. And especially when you're talking about this kind of broader conception of justice, accountability, fairness, treating American Indians on the same type of moral level as you would treat European settlers. And yeah, we continue to deal with this stuff into the modern day. You mentioned, for example, like the boarding school process, that era in history. It wasn't until 1978 that we adopted the Indian Child Welfare Act, which basically says, yeah, tribes have an interest in their own children, in being able to, participate in situations where a child needs to be, a child's needs aren't being met. The tribe has a right to assert over that process and a stake in what happens to that child. So something as fundamental as parenting and the ability to kind of organize your child's upbringing the way that you think it was appropriate, we're still dealing with the ramifications of that through Congress as recently as 45 years ago. So there were some good practical consequences from this. So first off, it did, at least in practice, if not in the law, it did set a precedent for issuing a writ of habeas corpus. This was subsequently kind of ratified by the U.S. Supreme Court just a few years later in a case Ex parte Crow Dog, which is another late 19th century fairly significant Indian law case. But that also involved a tribal member who had requested a writ of habeas corpus, was granted it. And in that particular situation, they really didn't even litigate whether, he was entitled to seek this remedy or not. It seemed like they had kind of accepted that the writing was on the wall and weren't really going to fight that. So in that sense, yeah, it probably did kick the courthouse door open, but only for this very limited harm and for, these very limited remedies. So in this particular case, the remedy, the wrong is the confinement, the wrongful arrest. So the remedy is let him go. Well, let him go where? We have a problem now because you've also said in this decision pretty clearly he can't go back to the Omaha reservation without the permission of the Indian agent. He can't go back to where he had been trying to live his life as a white man, as you have just kind of commended him for trying to do. He doesn't have any resources. If he's, separated from his tribe, you had destroyed everything that belonged to him when you removed him to Oklahoma in the first place. He doesn't have resources to be able to buy land, to be able to set himself up. So he is really in a position of dependence on the friends that he had been able to make through this process. So he was very fortunate to have Henry Tibbles and Crook and basically their efforts on his behalf, because Tibbles was very successful at ginning up a lot of support for the Poncas and their plight in the church community. Essentially, saw them as a good charitable case, a moral undertaking for them to support. So he was able to raise funds to basically help support them and put them in a position where they could move forward from this decision.
But again, there's nothing institutional about it. It's like some guy essentially asking, can you spare a quarter to enough people that they have the money to leave? Otherwise, they could have won in court and they would be like, okay, good luck. You guys are homeless on the street now. And
this is that sabotage that we're talking about, where you were living perfectly fine before we got involved. Yeah. So that was one of the big limitations there as well. He was fortunate that Poppleton and Webster they continued to be very interested in what was going to come of them, and so they actually were able to find a little bit of a loophole, another one that just worked to their benefit, fortunately, and that is in the way that the treaty language was originally described. It didn't include the islands that were in the middle of the river as part of the land that the Poncas, were being divested of. So these islands are then kind of in a no man's land, and that basically gave him the opening that he needed. He's not going onto a reservation now. This is just the same land anybody else would be able to enter on, and so he was able to return to these islands that were part of his homeland. He was able to bury the bones of his son in the burial ground where he had wanted to be laid with the rest of their ancestors. So in that sense, there is a little bit of a happy ending for Standing Bear. But in the broader justice sense, this doesn't even begin to remedy the injury that was inflicted through this entire process, from the point where the treaty is violated, to the property being destroyed, to the forced march, to the deaths, to this just deprivation of basic dignity, that you would treat another person with, and you take them all the way down to Indian country and then leave them there to fend for themselves because you don't want to take them back. Just Nothing, none of that is addressed or even really contemplated in this court decision as being something that can be rectified. So there is a little bit of an epilogue to this story as well, which is that we talked about how there previously was not any mechanism for the American Indians to go to court. This decision kicked open that door a tiny, tiny little bit, a little bit of a wedge here, this specific harm, this specific process. Well, it wasn't until about the 1940s that Congress decided, all right, we will finally go ahead and open the door for claims of these treaty violations and these mismanagements, this abuse of this guardian type of relationship will allow those claims to be presented. And so a lot of that was taking place during the 1950s, 1960s. Some of it actually extended to pretty close to the modern day, which would be an interesting show in itself to do sometimes on the Black Hills litigation. But so the PONCA, when this statute was passed, it created the Court of Indian Claims, which was basically an Indian commission. It was essentially a commission that their role was to kind of engage in fact finding and evaluate, whether there was any compensable harm that the claimants had suffered. So the PONCA presented a petition to the Indian Claims Commission, and they essentially alleged what we've been talking about in this entire video here, the violation of the treaty, the forced removal, all of that stuff. And so the Court of Indian Claims laid out all of that, quite a bit of factual detail. It seems like the facts of what happened really aren't in dispute. Really was pretty clear that there were violations of the treaty and stuff. But the Claims Commission essentially said, well, you subsequently entered into different agreements with Congress, and those basically rectified the harm that you sought. You already got your remedy. It was political. And so to the extent that there were monies that were allocated to you in these treaties, we've looked over the books that the government accountant has created, and we've found that they're just fine. There's really no discrepancy here. So no remedy ordered. Once again, the courthouse door is now open, but not necessarily going to be received with a lot of generous spirit in that context. Obviously, you can never really put a price on human life, but lawyers will certainly try to do that. And there's no effort on the part of the commission to account for the suffering, the loss of life, the destruction of essentially all of the property of the tribe, which incidentally was not minimal. This was a wealthy tribe. They had described Standing Bear's assets at the time of the removal. He was a wealthy man by the standards of this era, a few thousands of dollars in his estate. He owns farm equipment, nice buildings, livestock, grain that he has in storage. I mean, and all of it is just gone in a heartbeat. So no real indication that that is something that the court considered in making its decision. So sometimes even when you have a right and even when you have an avenue to ask for it to be enforced, we fall short when it comes to doing justice.
And I guess that, to me, this case, like several others involving native tribes, really raises a bigger issue regarding the process of conquest, the relationship between law and conquest. Because the reality is that if you look throughout history, there have been plenty of people who have just conquered unapologetically. They come in, they take over, I won, you lost, end of story. Your rights are whatever I feel like giving you, if I feel like giving you any. Otherwise, you need to deal with this. That's it. Which, of course, it strikes most of us as, ooh, that's pretty ugly. But there's an internal logic to it. It's coherent. It's just winner takes all, right of conquest kind of thing. Then there's the idea of like, oh no, we are a nation of laws. We enter into treaties. We go about it the legal way. And I think that's one of the process that's neither this nor that when it comes to the American experience, is that the colonies first, and then when it becomes the United States as a new nation, there will be this attempt to engage, to go about it in a way that both on a moral and on a legal standpoint, you can pat yourself in the back, feel like we are the good guys, because look, we are not just barbaric conquerors who are going about it in a legal way. But then you don't, because then all the treaties get broken anyway, and you have these kind of cases over and over again. And so it's like, why not just, like, if you're not going to live up to it, why even bother? Why put on the mask of we are moral and legal if you're not going to do it? Just say that you're a conqueror. And that's, again, you can argue that's ugly, but there's a logic to it.
Yeah.
Or you can argue that you follow the laws and there's a logic to that too, but behave accordingly. It's like, this is one of those cases where it's almost as at a civilizational level, there's this desire to conquer and get all the benefits that come from naked conquest through military power. But then there's also the desire to feel like we are the good guys, we went about it legally, we hold the line for morality. And it's like, those two things don't go together. Pick one or the other. You're kind of hard to try to use this line only when it's convenient, but then you switch, and I think that's part of the problem of this whole thing is the hypocrisy.
It
It's
is,
not
and
people have done it before, it's just the hypocrisy of it all that's annoying.
it is, and I think that is why we continue to struggle with this still today, because it's the bait and switch. It's not, so much what we did; it's how we went about it, and just frankly, dishonor that we showed when it came to living up to our word, living up to our commitments, to actually embodying the principles that we were telling ourselves that our country was founded on. So, that, like any decision, is going to have downstream consequences, but particularly in the law, because the law is an historic process itself. We depend on the process of stare decisis, the idea that prior rulings, they remain in effect. You continue to be governed by them. It's extremely difficult to get a precedent, of the U.S. Supreme Court, for example, overturned. And so what that means is that this law just builds on the other law, and we're left with a situation where these principles that are grounded in justifying conquest, but trying to rationalize it as a sort of legal undertaking, these are now baked into the law that we are still dealing with today. And I think a lot of people may not really be aware of what that legal status of American Indian tribes today is. For example, that American Indian tribes to this day, to economically develop, to access their resources, if you want to mine or harvest timber or something like that, you still have to go to the federal government to get permission to do that. The federal government is who collects the money for that and then divvies it out to you in the manner that it sees fit. This ward guardianship relationship is still baked into the law that we're living under. And given how much we've talked about the just tyrannical type of framework that presents, it's really alarming in many ways that in 2024, that's still the system that we have. So I'm really glad and just grateful that you took the time to talk with me about this case, because I think it really does touch on so many of these bigger, more important questions about what justice is, the role that the courts play in ensuring that, and looking at a situation where I think personally a good case can be made that we're not really in the ballpark of having achieved something like justice yet. We are not equally applying our principles to everybody in our nation, and so that's just something that I think it's important to shed light on as we kind of move forward and evaluate what rules do we want to live under? What sort of society do we want to have? Let's not forget, yes, it's, I suppose, a kind of niche area of the law. If you're not from the West like me, maybe you're not even aware of it. Maybe you don't even really care about it. but it's very important out here in the West. And I mean, pleased to say that at least in my state of Washington, we have a recent history of some pretty good partnership type relationships with the tribes. We have come a long way in developing these relationships on more of a footing of equality and partnership, recognizing you have your area, we have our area, but we have shared interests, particularly where things like water resources, fish, the environment, stuff like that is concerned. What we do affects each other. So we make progress. There's really no question about it. But this remnant in the law that continues to govern this relationship is deeply problematic from a liberty perspective. And so really appreciate you taking the time to share that problem, that justice problem, with our viewers today. Folks, I just want...
Thank you for having me.
Yeah, it's been my pleasure. And I just want to remind you again, check out History on Fire. You absolutely will not regret it. It's a fantastic podcast. I also mentioned earlier the Shogun series, if you're watching that, which I am. Professor Bolelli is very soon going on a trip to Japan where he's going to be helping guide with some of these sites that are talked about in this movie, this series. Which is actually based on historical events, loosely, but there is some historical underlying stuff there. So hoping very much he will share photos and maybe stories of that trip when he gets back, because I wish very much I could go.
Sound great. I'll definitely do that. Thank you again so much for having me. This was fun. I'm glad we got to do this.